of light that's reflected back. And then it creates a baseline IR voltage, infrared voltage. And then if there's a deviation, so the criteria for a confirmed tamper means that there's a deviation of more than 12% for at least 8 hours if no alcohol is detected. And then it has to return back to the baseline. And so in these events, there was no alcohol detected on any of the tampers. It was just straight tamper, so they all had to last at least 8 hours. The first tamper lasted from it was 8 hours and 5 minutes. The second tamper was on December the 10th, was 16 hours, and then the final tamper lasted for 30 hours and 9 minutes. And so what that means is that there was something in between the leg and the device that was that could be preventing the device from taking accurate readings. The easiest way to think of the IR voltage, I got my little flashlight here, and you can kind of see the light reflecting off my hand, and it measures that amount. If something lighter, like a piece of paper or a sock is interjected, it will cause more light to reflect back. If something darker is put in there, it'll cause less light to be reflected back. And so that's how we can determine that there is something in between the leg and the device during those periods of time. That's a real quick 30,000 foot viewpoint of how the tamper technology works. There is additional tamper technology in there to ensure that the device wasn't removed. And then obviously there's the alcohol component, which, like has been mentioned, there was no alcohol detected. It was just the tamper, the obstruction.
Okay. So if I understand what you're testifying to, it's that there's very likely some item between the ankle monitor and the skin that was preventing an accurate reading. Did I get that right?
Yes, sir.
And it could have been an article of clothing or whatnot.
Yes, sir. And I can't make any guesses to what it may have been. I will note when we do the install, when my staff perform the install and it goes over the paperwork with all the participants who are on the Scram Cam device, there's it's quite lengthy paperwork, and it has a lot of do's and don'ts. And one of the big don'ts is don't put anything between the leg and the device. It also talks about personal hygiene, and if for any reason there's any swelling or medical issues, kind of steps to take for that. So yes, sir.
Okay. And are these, so these obviously are in constant contact with the skin. Teach me a little bit about how what your steps are, or what the protocols are to prevent, chafing or otherwise the equivalent of a bed sore being created with something being in constant contact with the skin.
Yeah, so I will say that the device is hypoallergenic, so it's supposed to help with that. There is the faceplate on the device is nickel, so there is if someone has a nickel allergy, they're not a suitable client for Scram Cam. The device itself, we have seen in the past, and it hasn't happened very often, but the buckle can cause some irritation. But that's why there's enough room to move the device around to try to prevent some of that. Obviously, if there's other medical issues, or like if the legs swell extensively, if they have other pre-existing conditions, diabetes, congested heart failure, things like that, that could cause complications. But the device itself, we obviously don't want to cause any harm or damage to any participant who's wearing our equipment. And so all precautions have been taken to ensure that doesn't occur. And when I say constant contact, Judge, I'm not talking about like super tight. It just has, like, if you think about it on a leg, we got to be able to put one finger between the strap and the participant's leg.
All right, so it can rotate around an axis around the ankle.
Correct. It should be. You have to do it with a little bit of pressure. It should not be free spinning.
Okay. All right. I don't know. Any questions?
When you said that there was no alcohol detected detected, if by tampering, would it not allow the device to detect if there was alcohol present?
That is possible. The reason that I specified specifically if there was alcohol detected or no alcohol detected, because that changes our criteria for confirmation. So if no alcohol is detected in conjunction with the tamper, then it's the 8-hour window. So that would be 16 tests, 16 readings of the deviation of the baseline. And if alcohol was detected, our criteria drops down to 3 hours versus the 8 hours. So that's the reason why I was specifying that no alcohol was detected, because it fell under the 8-hour criteria versus the 3-hour criteria.
So, despite your very good explanation, because I think it was as clear as it could be, I'm a little confused. Is it your opinion that during, like, prior to the detection, prior to the tampering, during the tampering, or after the tampering, that there was any alcohol being consumed, or was the device simply tampered with?
The device was simply tampered with.
All right. Okay. Any other questions?
Yeah. Mr. Page, me and you had a conversation yesterday, didn't we?
Yes, sir.
All right, and you gave me a little bit more information, and I know that this may not be relevant to this defendant, but I did want you to explain a little bit about what the alcohol, if it was over a .2 after the obstruction was removed, would it be considered an alcohol-related event?
Yeah. If there was alcohol detected and it met the threshold, which is the 0.02 for confirmation, and it met the additional criteria for alcohol confirmation, we could have confirmed an event. But there was no alcohol detected with this event. There was no alcohol events indicated in the system that there has been any alcohol. Like I said, there hasn't even been like alcohol detected alerts on this participant.
Okay, so no alcohol at all, at any moments.
Yeah, correct. There has not been any alerts that's been generated from the device for alcohol readings.
Okay.
And Cody, as far as these sensors that we're talking about, is it a single sensor or are there multiple sensors on this device? So is there a tamper sensor? Is there that the infrared thing that you were referring to, and then an additional sensor someplace else, or is there just a single sensor?
So there are technically 3 different tamper technologies in the device. So the one for obstructions, which is the event we're talking about now, that's the infrared. And so, like I said, that's the infrared, and I explained that with the flashlight. The secondary tamper technology, there are the strap. If there's damage or anything to the strap, we could and the buckles damaged or anything, that there's also tamper technology there. And then finally, we have the temperature technology, which is used more for removals and other tampers along those lines.
But I guess what I'm asking is it possible to obscure the alcohol, GPS, and tamper at the same time, or can you maybe obscure the tampering but still be getting alcohol readings? Does that make sense?
Yeah, absolutely. And yes, you absolutely can have an obstruction. So this happens on depending on the material that's used. We've seen this in the past where someone will excuse me. Let's say they are preparing a drink, so they put something in between their leg and the device to attempt to defeat the equipment. They start consuming alcohol. They forget how the transdermal device works, removes the tamper once they start feeling sober again, and then we start getting alcohol readings. But also, depending on what material is used, it could be a permissive material that allows the vapors to still get through the device, get through from the skin to the device. But that's a very rare, and it would have to be a certain material.
All right. Step out, please. All right, go ahead.
Cody, as far as this defendant is concerned, are you aware of any repairs or adjustments that were made as far as James here?
Yes, sir. I believe my staff met with him, I believe in Coweta County, and performed a maintenance. So obviously we had the initial install that occurred, and then we did have a maintenance that was occurred for I think a fit adjustment. Yes, sir.
Was there a reason for the fit adjustment?
I would need just a second to review our business records on that, if that's okay by the court.
Yeah.
I guess you.
I think this is the guy with his swollen ankles.
Yes, sir.
Okay.
Yes, sir.
I remember that being part of the question that we were trying to figure out.
Yes, sir.
Yeah. We also did a battery faceplate maintenance on the device at that time as well.
And Cody, what is a battery? What's a
Battery faceplate remove. Yes, sir. So the devices, they don't have to be charged or anything by the participant. They do have a small, basically like an old digital camera battery inside of them, and then the faceplate is the actual like collection chamber for the device. And so it has to be replaced approximately every 60 days when used in conjunction with house arrest.
So does that battery have the sensor in it? Is that what you're saying?
So no, so the battery, I mean, we have a battery sensor, and so when the battery gets to a certain level, then we have to do a maintenance. We always do it at 60 days. That's when the system will flag that it needs to be replaced. The battery will obviously last longer than that, but that's when we do. If someone is on the Scram Cam device with house arrest, we're at a 60-day maintenance window. So every 60 days, we have to perform maintenance on the device to ensure that it continues to monitor properly.
And as far as, does this thing have GPS location?
Not GPS, it has radio frequency. So that's with the base station to ensure that and so there's a base unit and then the device to make sure it stays within range. It's designed for like house arrest for people who are supposed to stay at home or have curfew. It doesn't actively track GPS monitoring, no, sir.
And are there any alternatives as far as placement of this sensor, the monitor? Can they wear it on the wrist, around their neck?
No, sir. The device, according to the manufacturer specifications, is designed to be worn on the ankle. The reason that wrist worn technology in the transdermal space haven't really taken off is obviously on your ankle. Most of the time, people will wear pants and or put a sock over it to kind of cover it so other people don't see it. But when you wear it on your wrist, you're exposed to a lot more environmental issues and everything.
So is there a environmental contamination concern?
No, there's the device when it takes an alcohol reading, there is a contaminant test that's ran every single time to ensure that it's not like in an alcohol rich environment, to ensure that it's an actual alcohol consumption if that ever occurred.
And have you had any occasions to see medical issues arise from the use of the device? swelling of extremities, redness, any kind of, I think you mentioned, an allergy to nickel. Can you talk about that a little bit to the judge?
Yeah, if a participant has a nickel allergy and they're unaware of it, and it presents itself, I have absolutely seen that before. But the device would be removed immediately, and that's part of our paperwork. There's a whole section of the health and safety warning on there, and so and your question about swelling, I've never seen the device cause the swelling. I have seen individuals who had pre-existing conditions that did cause their extremities to swell and then cause discomfort.
And what was y'all's response to those situations?
So so our policy is that if it's causing damage or harm and it's being reported to us, and it's been observed and everything, we'd advocate to remove the device and use an alternative technology if that person is not a suitable candidate for the Scram Cam technology. If it's just a little, sometimes you could get like a little rub or whatever on there. If the participant's not having serious issues with it, then that could be common and be fine. But if there's like a nickel allergy, I could spot that from a mile away. So if someone's leg is breaking out in a rash, the device needs to come off immediately, and that actually is detailed in the paperwork.
I jumped in, Mr. Hudson. Do you have any other questions?
Yeah, just real quickly. I'm sorry, I don't have the paperwork in front of me. What was the date that the ankle monitor was put on this particular participant?
He was installed on November the 24th, 2015. So he has been monitored for 81 days.
Okay. And then there were there were 3 separate dates in December where there was an interruption. What were those dates again?
That would be the December the 10th, 2025, December the 9th, 2025, December the 10th, 2025, and then December 22nd, 2025.
And have there been any interruptions since December 22nd?
No, ma'am. There's been no confirmed or even potential tampers, and there's been no alcohol detected alerts generated.
And then you mentioned that even though it doesn't have a GPS, it has a base and there's some sort of location sensitivity that if you're not in the home and if you're away from the base, then that would be detected. Is that true?
Yeah, yes, ma'am. It just the device, home or not home.
Okay. So has there been any violations on that?
So there's been alerts, but there's been justifications for it. I don't think there's been any unauthorized ones, but I would have to defer back to the probation officer on that because we just provide the information, and then because I think the court order.
Have a doctor's appointment or not, he could be
Correct.
be at the doctor's. You don't know that. You're just
Correct. I just know if they're a home or not home. So yes, ma'am.
Okay.
Thank you.
And generally, I'm well aware that under proper procedures, we don't generally let one witness ask enough questions, but we're here to learn as much as decide. So do you have any questions directly?
Well, Cody, I just wanted you to, how many years of experience do you have with the Scram monitor? Just so everybody kind of knows how long you've been working with these devices and, how many years you've been available to see different things and situations with them.
Yeah. So I began my career working with Scram in October of 2007. And I've worked with this technology as like an installer. I started as an installer with the technology in 2007, and then I done that, and then I went to work for Alcohol Monitoring Systems, which is the manufacturer of the Scram Cam device. I worked for them for 4 years, and then I've come back to PronoTrack and been running PronoTrack since 2020. I have testified across the Southeast on the Scram Cam technology. I actually have to testify tomorrow in Tennessee. So it's a pretty regular occurrence for me to have to do that. So I've been working with the technology for a good while now.
Okay. So can you confidently 100% say that on December the 9th, within the 8 hours that it was obstructed, December the 10th, within the 16 hours that it was obstructed, and on December the 22nd, the 30 hours that it was obstructed, that he did not consume any alcohol?
I can't say that with confidence. I mean, because there was an obstruction occurring at the time of those events. So I can say before then, after then, and all that there's been no alcohol detected or anything, but there was obstructions during those periods of time.
And I just thought about, isn't there a patch option also, or is that just for different substances, not alcohol?
Correct. The patch is more it's designed for more narcotics and other drugs. I mean, it's basically a 15 panel drug test that they just wear on their arm. It's that collects the sweat over a period of time, like up to 2 weeks, and then that's sent to a lab. But it does not detect alcohol or ETG or any of the other metabolites that are commonly used in alcohol detection. Yep.
Do you have a recommendation on this case?
No, sir. I would not speculate to give a recommendation on that, sir. I just provide the facts of the device.
That's all right. If you had a recommendation to remove it or something, I just wanted to make certain that was clear on the record.
Yeah, if he had a medical issue and everything, I haven't seen or heard that there's a medical issue component of that. If that is the case, then if there's a medical issue, if there's a rash on the leg or something like that, then I would absolutely advocate for removal. If there's any sort of medical issues, I would advocate for removal. But if there's not a medical issue, if it's just like a little rub on the ankle, like the back of the ankle from the strap or whatever, that's normally very, very minor. But if anything arises to a medical concern, absolutely, I would advocate for removal.
Okay. And you have nothing about that in this file?
Nothing that's been brought to my attention. No, sir. I'm looking through all the.
Again, I'm just trying to make sure the record is clear and clean as to what are we looking at and what are we not looking at. That's all.
Judge, if I can speak, Tyler from his office sends me emails in regards to Mr. Huey. And so Cody's not doing the maintenance. He may be able to verify, I'm assuming Brent's probably aware. But there was an issue with the swelling. I'm pretty confident that Pronto met with Mr. Huey, and I think they put a longer band on his leg to accommodate the swelling from the previous band that was on his leg. I don't have the date of that.
That's all right. That was corrected.
I believe it was the 10th. Or was it January 27th? Is that the date that you told me?
I don't think it was that recent. I think it was a little bit older. I just don't, I don't know if it happened. I'm pretty confident it happened after the tampering is when the longer bracelet was, or bands put on.
Okay. All right. And again, I know we're doing this kind of out of the structure, but we knew when we walked in here that this was about education and course correction both. And I appreciate everybody's willingness to be a little flexible in the court procedures. All right. Anything else, Mr. Hudson?
Real quick, Cody, as far as medical issues, if someone was to get an x-ray or a CAT scan or an MRI, or what do we do as far as that? Would that have any effect on it?
Yeah, if it's
Those kind of things?
X-rays, I don't believe there's any issues unless they're X-raying that specific leg. CAT scans, MRIs, we always would remove the device prior to, and then once the medical procedure has been completed and cleared, we could reinstall the device.
Do you know of any shunt in his brain. Would that have any impact on the device that you know of?
Not to my knowledge that there's anything with that. The only medical device I think that can cause that I don't think it can cause an issue, but I think it's in the health and safety warning is pacemakers.
That makes sense. All right, anything else? Anything else? Anything else? All right, you are free to go, Mr. Page. Thank you very much. Again, as you're well aware, the goal here was to learn a little bit so that we can both deal with this case effectively and future cases as we roll this project out.
All right. Thank y'all very much.
Thank you.
Thank you.
All right, anything else, Director Matthews? All right, do you have a recommendation on this?
I do.
Okay.
When Mr. Yu was previously arrested, and Brett and I have had conversations, I was asking for a full revoke. I already had that approved by the solicitor's office. Mr. Hutchinson talked me in to this situation. So my recommendation would to be revoke Mr. Huey in full. In lieu of that, because of medical conditions, I told Mr. Hutchinson that the current order is for 180 days to remain on the monitor. He's 81 days into that. He has 99 days remaining with an estimated removal date of May 22nd of 2026. In lieu of him being incarcerated for the rest of the case, I feel that he should then wear the monitor for the rest of the case.
Any argument or position?
Judge, and I agree with Marty, I may have talked her into it, Judge, I don't know, but the circumstances involved in this case is that James is a caregiver for his mama. He stays at home. He's got medical issues of his own. The family was concerned about alcohol consumption. I know the court was concerned about it. I know probation was concerned about it. And so I guess what I'm saying as far as, and we had the incarceration, and so the alternative to that was the house arrest. Based on the evidence that we've gotten, he's been compliant with staying at the house. And as far as alcohol consumption, I know that that's kind of a catch-22. There's these time periods that it's possible that he was or he wasn't. But we also had evidence that, if he would have put it back on and he would have been over a .02, it would have logged it in as a alcohol tampering, okay? So the longest was 30 hours, 16 hours, 8 hours. He can't explain it. I can't explain it. I just know that he was going through some medical issues, Judge, and I can't say that I wouldn't have tried to jam something in there if I was going through some discomfort or whatever to get some sleep. He doesn't remember doing any of that. The fact of the matter is that's the evidence that we got. But if the objective was for him to stay at home and not drink, I believe we've accomplished that. I want to double down on that, Judge, is that the last known tampering event was December 22.
Yes.
And we're in February right now.
Yeah, and that's going to be a huge part of my decision making.
Yes, sir. And I appreciate that Marty wants this to be on longer. I have my concerns medically.
Yes.
That's if we need to restart the clock on the 180 days, maybe. I don't even want to advocate for that, Judge, but I understand we've got to do something. We've got his attention. You'll notice that once we had that pretrial conference, I know James was a little irritated at me for calling him and saying there better not be another tampering event or anything like that. But we had that conversation maybe 2 weeks ago, and we haven't had anything in 2 weeks. But before that, we didn't have anything, Judge. And so I'll be quiet now. Like I say, I'm on this kind of monitoring. I'd usually be concerned about the financial aspect of it for most folks. I don't have that concerns. I'm sure James doesn't want to pay for it, but the alternative is jail. So he's paying for it. So I'm not worried about the financial part of it. I'm more concerned as far as James is concerned about the medical impact.
No, I'm with you.
Yes, sir. So
Okay. I know you're not truly involved in it. Do you have anything else you want to add? Yeah. All right, perfect. Anything else on that message?
Just for everyone to be aware, there's 472 days remaining on the case.
All right, I think that we need a good, long runway of success here. It does appear to me that this was a series of events that occurred within 30 days of installation, if I understood the testimony correct. Um, and, and so because of that, and I'm aware that this case was going to be a jail case until it wasn't. And so I just want to make certain that that is not lost on me at all. But I do think that for today, at 10:28 this morning on February 12th, I am going to order that the ankle monitor stay on through the remainder of his probation, and I'm going to order that his probation be 0 tolerance through the remainder. In other words, you figured it out, Mr. Yui, how to do this right, and I expect you to keep doing it right. You keep doing it right, y'all can come see me in 12 months, and I'll reconsider. But between here and there, I need to know that you're doing it right. I need to do that you're doing it well. And I'm hearing Pronto say that that you have figured out how to make this work. Okay. So the official decision is for the remainder. If defense wants to come back after 12 months, you can come back next February and ask me to cut it loose for the last 100 days or so. And I would certainly be willing to consider it if we've had no issues. But frankly, if we've had no issues, if we've had any issues, he's very likely going to be revoked to the jail because that's the edge of the cliff he's standing on anyway. All right. All right. Any questions, Mr. Hudson?
No, Your Honor.
Anything, Ms. Hudson? Anything, Director Matthews? Okay. All right. Then that concludes this hearing. Mr. Yu, you'll sign your paperwork with your attorney, and they'll give you an extra report day if they haven't already, and then you'll be good to go. All right.
Mr. Dewey doesn't have to report, we put him in non-report.
That's right.
with the non-
Sorry about that. I knew that as a gesture. So, okay, everybody out in the gallery, that's all my attorneys, right? All right, everybody in the gallery, what we're gonna do is I'm gonna step off the bench, and the conferences are gonna start. Let me be very clear about how conferences are gonna go. Number one, Director Matthews or a member of her team are going to speak with you all who have probation matters. You're going to be presented with the state's recommendation. The recommendation is simply a switch. You flip your switch to yes, you accept it, or no, you don't. If you accept it, then you'll be allowed to sign the consent order. You'll be given a copy and you'll be free to go. If the consent order is not acceptable to you, then at that point, you will be, you'll just say no thank you, and you'll be sitting down, and as soon as I come back out, we'll have your hearing at that point, and then I will sort it out. I have a couple of people where I've been looking for attorneys. The attorneys are not here, and so I'm going to release Henderson, you're in the back somewhere, until Monday, and I'm releasing Scholin, where are you? Until Monday. I'll see both of you all Monday morning in not this courtroom. You'll go to the second floor courtroom at 9 a.m. Monday morning. Judge Essery will be calling that calendar. So Monday morning, 9 a.m., second floor courtroom.
Question.
Yes.
If my attorney not here for the 5th time, then what?
Then
It would be my 5th time coming.
I'm aware of that, and I'm gonna let you talk to her about that on, I asked her to reach out to the solicitor's office and to you. I'm gonna let y'all work that out on Monday. We will address it on Monday, okay? All right. Tolan, you're good to go till Monday. I'll see you Monday at 9 a.m. Second floor. Anybody else is anybody else for the trial calendar who's waiting on their attorney to get here? Trial calendar?
Witness against him.
Okay, then you're good to go. Do you want to talk to him before he goes?
Yes, I do.
Okay, talk to Ms. Sexton. All right, with that said, again, conferences are not a big discussion. If you say yes, great. If you say no, great. It is not a dial, it's a switch. All right, you're waiting on your attorney?
No, sir, quick question. I need to speak with.
Judge, he's your pro se motion that's
Oh,
on the calendar.
I'm gonna hear this when I get back. You're good, you sit down.
I think he wants an interlock waiver too. So he wants to modify probation.
Ah, okay.
Apologies.
Show the bailiffs any paperwork you have, they'll get it to me in the break. All right, that's it.
Judge, one more thing.
Yeah.
His client
Anderson was directed to appear Monday at 9 a.m.
Can I ask you something, Your
Yes.
Honor? Because I was confused and I just need some clarification. The person that stood up in court and was complaining about their attorney, was it this case or was it a different case?
No, that was Sharon Henderson. She was unhappy with Ms. Scott not
Okay.
being here.
Okay,
So,
thank you.
all right, so that one's off this calendar. Huey, we had that hearing. That matter's closed. Johnson, ignition interlock, that was granted previously. Kilpatrick?
Consent.
All right, so there's actually nothing left on page 2. All right, on to page 3. I see on a Marshall.
Consent.
Do I need to have any sort of hearing on that? Or control?
We've
For
kind of
today.
continued it
Yes.
until later this month, so
Okay, that works. So hopefully she'll get it closed. If not, I'll deal with it.
that's right.
All right, that works. Prayer is off. Kellis Price had 2 matters, an ignition interlock device request and a probation modification request. Is that correct?
Yes.
All right, Mr. Price is still here. I reviewed his paperwork on the ignition interlock device and I granted it. I believe the order's been filed, so that part is off. We'll have a short hearing on the probation modification, and we'll figure that out. All right, so ignition interlock granted, probation modification we'll have a hearing on, and we'll get Mr. Price out here. Russell is off. Smith?
Consent.
Excellent. Hunter Smith. On modification. Ms. Sexton, did you have a chance to speak with Mr. Smith?
I'm sorry, Your Honor, I have not talked to you.
No, that's perfectly fine. Well, I do the other hearings. Mr. Smith, where are you? I'm gonna see if Ms. Sexton, would kindly speak with you. She's our solicitor. And see if there is a resolution. And then also give you a chance to talk to your victim advocates, Ms. Sexton, and see if there's any input from the victims or whatnot. I don't know anything about the case. I literally don't know. Is that-
Dixie's here.
That's you? Okay. All right, Ms. Sexton, you take all the time you need to figure out what you want to do.
Okay, thank you.
All right, Jennifer Stevens.
Consent.
Okay. All right, Talmadge.
Judge, that's, the case we continued from last week. They refused to consent, so no consent was offered today. That would be a full hearing.
All right. Tolan was told to return on Monday, but but Mr. Van Nader's office then reached out and said he has leave next week, so I'm asking to just move it to whatever calendar clerk. So Ms. Sexton, you're off the hook next week for Marty Tolan.
Okay.
I have reset that to just a whole nother calendar because Mr. Van Nader has a conflict, has a leave-in for next week.
Yes, and we actually had a witness here today who's presented like 3 other times. And
Yes.
so I will personally contact him. I have his email and his personal cell phone number, and I will contact him and tell him he does not need to show up.
Yeah, the attorney has leave-in and the judge granted the leave, and so the case is off through no fault of anybody's. All right, Tevin Willis was a show cause. He's not here. He's in prison. That's not my problem. And so he'll continue until he's not here. All right. All right, Director Matthews, I'm gonna give the calendar for you to call, and then, we'll just, Ms. Sexton, what we'll do is we'll just work our way through the probation matters while you figure out what
Okay,
your
that's what I was
position is.
hoping.
Yeah, you're off the hook for the probation matters. I'll deal with those if you'll deal with the bond Smith question, the bond question on Hunter Smith.
And who is that she has to sleep?
She needs to talk to Smith, but she also needs to talk to the named victim in the case too, so.
Which one you want?
Let me talk to the named victim first, and then.
And who is that? Come on.
All right, Director Matthews, the calendar is yours to call as you see fit.
I'm gonna go with Mr. Price first, Judge.
All right, Mr. Price, if you'll come on up to the podium here.
Good morning.
Good morning, Mr. Price. If you'll please raise your right hand for me. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take your hand down. State your full name for me.
Kellis Neon Price.
All right. Mr. Price, you're here on, 24 SR 0739. Oh, I just realized the order that we issued, it was on a different case than this one. Do you have the order handy?
I gave him the.
Oh, what's the case number on the order that we just gave you?
More than likely
Two-
24 SR
24
1870.
SR 1876.
1876, okay. I just realized I need to put that on the record, that the ignition interlock device grant was on 24 SR 1876, which was not on this calendar, but it was circling it. And there, our actual probation modification is on 24 SR 0739. I just needed the record needed to be clear that the order I issued already was on a different case than what we're about to talk about.
Yes, sir.
All right. Mr. Price, tell me what you're looking for from me today.
Okay, sir. I've been working closely with my probation officer and my DCR officer because the case was like overwhelming. So they're working together now to keep me in compliance with both. Part of that is, as you know, the license. So, and the next thing is scheduling, which will be, the 30 days, jail time. I got proof of incarceration. It was an initial, that she said that I need to come speak with you about, that they could move forward with using the time that I already served, which was the 60 days, the count, so the 30 days will be, in full.
Okay, so what I've just heard from you, correct me if I'm wrong, is that you have 30 days that you need to serve, and you were asking for time that you have served to satisfy that obligation. Is that correct?
Yes, sir, that's exactly how she said, yes, sir.
All right, anything else?
No, sir, you've done away with that, that'd be all, sir.
All right, we're good to go then. You have an open old felony?
No, sir. No, sir, nothing open.
Oh, is this 15R 143, is this the parole thing that got you back in, that put you back in the jail for the 60 days that we're talking about?
Yes, DUI.
Okay, that's the 15R 143, it's an old felony, and I see a recent magistrate order from May 23rd of 23, ordering you to be picked up. It's very confusing, okay. We'll figure it out.
Yes, sir.
All right, Director Matthews, fill me in on.
So Judge, the way this case was actually ordered, it was ordered for him to complete the DRC program, and that it gave us permission to use completed items between the programs at our discretion. So, what he's saying, working with his felony officer, that's part of the order that the court's already provided him. The 30 days in jail, we have not received documentation that he served 30 days in jail on this charge. I have received proof of incarceration that date he received on January the 20th of 2026 that states that he was arrested on May 22nd, 2025. He was released on July 11th, 2025, but he was held there for a parole violation. He was not held there on either one of these DUI charges.
Okay, so it's not whether or not he served time, it's whether or not he served time on this specific.
Correct, yes, sir.
All right. And his current sentence, does it require 30 days to serve?
Yes, sir, and he's supposed to get that date scheduled with us by February the 14th of when he is going to, he's supposed to turn himself in by February the 14th. He was sentenced on January 15th, and the court order states that it has to be began within 30 days.
All right. I think I've got my brain wrapped around what you're looking for here.
Yes, sir.
Anything else, Mr. Price?
Yes, sir. The DUI that was actually the replication. It was the DUI. That's why, you know how you get locked up and then they put a hold on you because you got locked up? basically what happened. I got the DUI, that's how I revocated. I didn't do anything else. So that's why I was locked up.
There it is, okay. Yeah, so you have the 24 SR 1876. That's a DUI from November 30th of 2024. And then, Carly, we actually need to merge those two. There's two Kellis Price. I think that's part of the confusion. And then I have 24 SR 739. That's a DUI from 11/4 of 23. Okay, well, so Mr. Price, my take on your, so again, just say it out loud. The ignition interlock device, that was granted. Sign that order, you have it in your hand, you're good to go. Take a copy of that to DES
Yes, sir.
to get that moving forward. As far as giving you credit for this time that you've served, frankly, I'm going to defer to the sheriff's office on that issue. I generally do not get involved in who gets credit for what unless it's a very clear question. In other words, unless the sheriff has committed what we call plain error, just something on his face that's so obviously wrong that I need to fix that. Because that's our division of labor. Our division of labor is I make the sentences and then the sheriff executes those sentences. So if you get there and the sheriff decides that that time that you served should apply, then the sheriff will apply that time and you'll be done. But if the sheriff decides that that time does not apply, then you will need to satisfy those 30 days as the sheriff directs you to. Does that make sense? That the sheriff is the decider on the question you're asking me, not me.
Okay. Yes, sir. Well, it's still a little confusing because, my, Ms. Fennessy, my probation officer, she said that, she don't have a problem with letting it be satisfied. It was just, this paper right here. She said that it had to be initial saying that you would, that you're not against it. And that she would let, that serve because 30 days in jail will also, I wouldn't be able to do the DRC.
Okay. And just so you know, when you held that document up in your hand, am I correct that look in the top right corner, is that your final disposition on 24 SR 0739?
Yes, sir.
Okay. I just want to make sure you knew that the document you're holding in your hand, I have on my screen right here.
Yes,
so
sir.
we're both looking at the same document at the same time.
Yes, sir.
I just want you to know that.
Thank you.
But what I need to point out to you is the line underneath the sentence where it says, credit granted for all time previously served in this matter, followed by probation. And then it says underneath that, the sheriff shall calculate the actual time to be served in jail, if any, which the court shall not review except by motion to correct a plain error. And so that the whole point of that is so that if you've got 30 days and you're there, we'll go. So I will look into this additionally. I'm not currently inclined to initial that line. The line you're talking about that you need me to grant to sign is 2 lines up from where I'm reading.
Yes,
and it says jail time served in full.
Yes,
or
sir.
to initial.
Yes, sir.
And I initial that when during the plea, the state and the defense agreed that any time served has already been served. But no one asked, clearly nobody asked me to do that on January 15th.
No, sir. I didn't have that understanding. That's why it was so confusing. That's why I reached out to my DRC officer and my probation officer to help me with this because I didn't know how I could satisfy both. And being incarcerated, I can't.
I know. And I'm hearing what you're saying. And
Judge, but the way this order's written up is that he has to do it in weekends. So it'd be 15 weekends in 48-hour increments.
Yes, but I work on Saturdays. Mandatory.
I was just trying to make sure you understood it wasn't 30 days straight.
Yes, ma'am. I work on Saturdays and part of, and also I have to have, I had to have employment.
All right, at this moment, the answer is no, but I'll take a second look at it after court today. If I change my mind, you'll be notified. They'll give you a copy of it at your next report, okay? But as of this moment, you may get exactly what you want, but you get it from the sheriff.
Yes,
So
sir.
I'm saying, the answer is just, you're asking me to step into the sheriff's lane, and I am not comfortable with that.
Yes, sir.
But I will take a good second look at it because of the overlap with GDRC. And I frankly don't want to set you up for failure. But at the same time, you are correct, Director Matthews, that this is set for 48-hour weekly increments. So, okay, when's this next report date? No, there's no apology.
The 5th.
Fifth?
Yes, ma'am.
Okay.
Yes, sir.
All right, so, if I change my mind, you'll receive an order at your next report date saying that I've changed my mind and here's what we're doing, okay?
Yes, sir.
All right, you got 1 out of 2 for me today.
Yes, sir.
All right, thank you, Mr. Price.
Thank you, sir. I have heard.
Thank you.
Judge, the only two things we have left is Mr. Hunter Smith that Ms. Six was talking to, and then we have Ms. Talmadge. I don't know if you wanted
Yeah.
to do Ms. Talmadge without Ms. Sixon?
Yeah. All right, Sounds, come on up. While she's doing that, I'm gonna grab some off the printer. All right, Ms. Talmadge, please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down, state your full name for me.
Wakilia Talmadge.
Ms. Talmadge, you're here today because frankly, we were trying to have your hearing last week. You've been offered a consent, you've refused that consent. We were trying to have your hearing, but we were having major technical difficulties with our internet being down. We couldn't look anything up. I couldn't look anything up. I was locked out of my system, so was Director Matthews, and I had to reset you to today. I am
Yes.
sorry to you for any difficulty that caused you of having to come back for another court date. We reset yours and a couple of others, I believe. You were not the only one. So,
Yes, sir.
all right, so let's jump right in.
Okay.
Do you understand that you are here today because your sentence enforcement supervisor has filed paperwork with this court alleging that you are out of compliance with your probation?
Yes, sir.
You understand that you have the right to have an attorney and you're here representing yourself?
Yes, sir.
Is that what you want to do?
Yes.
You ready to go forward?
Yes, I am.
All right. So Director, do you have a recommendation at all? That's fine. All right, so then I'm just going to read it out. The allegations are, A, that you failed to report to probation and that you missed 2 scheduled reporting appointments. Do you admit or deny that allegation?
I deny it.
All right, and then the second one, there's only 2 allegations. The second allegation is that you failed to pay your fines and fees or use community service work to resolve those. Do you admit or deny that allegation?
I deny it. But I'll have to explain.
Well, that's a denial on both. Grab that first seat right there.
Okay.
As we're moving into a full-scale hearing, I'm going to move you into your official spot. All right, so, Ed, if you will, Robert, sorry. Okay, so what we're going to do next is Director Matthews, who's already been placed under oath, is going to testify as to the state's facts as to how these allegations came about and what they believe supports them. I'm taking what's on my paper here as questions that I'm supposed to answer. And so I'll take their evidence in, and then you can ask questions. And then you'll be given an opportunity to make a statement after that if you wish. And of course, if you make a statement, you will be required to answer any additional questions that are asked of you under oath. Do you understand that?
Yes, sir, I do.
All right, Director Matthews, the floor is yours.
Yes, sir. So on allegation A, missing 2 of the scheduled appointments, Ms. Talmadge was emailed on October 17th of 2025 to report between November 1st and November 15th. We did not receive an online report. We then gave her a phone call on December 5th to advise her to report by December 15th, and she did not report by December 15th. So that is the 2 missed appointments. She is on online reporting. And for allegation B, being arrears $725 as of the date that the petition was drafted. To this date, she has not made any probation payments at all on this case. The current arrears as it sits right this moment is $860. Her payment plan was $135 each month. She's been on probation since August.
Okay. Ms. Talmadge, do you wish to ask any questions of Director Matthews? If you do, just be nice and slow and loud and let her answer, and that way Ms. Terry can record everything properly.
Okay, so Ms. Matthews, when I was here last Thursday, you talked, well, okay, did you tell me that I did not complete the second opportunity program, in full, and there was a probability that I didn't complete all the courses?
Correct. You alleged that you had completed the entire program of Second Opportunity, which would be Second Opportunity, U-Turn, CRI, and soft skills. Once I started to explain to you how many courses were involved with each of those different sections, then you stated that you had not completed all of those.
Judge, could I show you my certificates, from where I completed all 5?
We will get to that stage in a minute. So you
Okay.
hold that thought. The answer is yes, but not
Okay.
right now.
Okay.
So at this moment, you may ask questions of this witness.
Okay.
You'll be given a chance to testify when it's your turn. And of course, if you testify, you will be cross-examined if Solicitor Sexton chooses to do so.
Okay,
All
so.
right, do you have any more questions for Director Matthews?
Yes, a few more. With the second opportunity program, are those hours, do they only count for, only the community service hours that I was ordered to complete at the beginning of my case? Or, could you apply the excess that I, completed to my probation fees, remaining probation fees?
So they can be used towards the court order community service, and they can be used towards a conversion as well.
Okay.
Up to this date, you have not came in and requested a conversion, nor have you signed a modification order with the court requesting that we convert your fine into additional community service. So therefore, there are no converted hours on your case.
I don't think I have any more questions for now, Judge.
All right, Director Matthews, anything else you want me to know?
Judge, just to be clear, my allegations in regards to community service, I can only testify to what has been turned into my office. If additional certificates have been completed and not turned in, there's no way that I could allege. We have 2 certificates that were turned in on December the 5th. We gave her 10 hours for paying the $89 fee to sign up for Second Opportunity. And then for the 2 certificates that we've received, we gave her 10 hours. And so that completed her court order 20 hours on her case.
Okay. All right, any other questions for this witness, Ms. Talmadge?
No, sir.
All right. Any additional witnesses, Director Matthews?
No, sir.
All right, so Ms. Talmadge, what I'm gonna do is, since I've already got you there and I've got the court reporter's microphone there and I've got a regular microphone, I'm just gonna have you give me your testimony from that seat, instead of bringing you up here to the actual witness seat. Once you've given your testimony, Ms. Sexton may have some questions for you if she wishes. All right, and you have the right to remain silent, do you understand that?
Yes, I do.
And if you choose to give any testimony, you will be required to answer all questions allowed by law.
Yes, I do.
All right. And is it your wish to testify or remain silent?
I want to testify.
All right, tell me what you want me to know.
Well, Judge, I did submit my certificates as soon as I got done with the Second Opportunity Program. I have an email here from Second Opportunity that says, congratulations on completing the Second Opportunity Program. And I submitted those to Ms. Peterson on on October 31st. Well, let me see, October 26th is when they emailed me. I said, hey, I have completed Second Opportunity. I have 43 hours of community service credit. And then that's when Ms. Peterson emailed me back on the 31st and said, did they send you any certificates? I said, yes, 5, I believe. And I submitted those on November 4th. And that's not true what she's saying on her record for December. I think she said 4th. But I have here where I sent Ms. Peterson my completed Second Opportunity Program certificates. And I just want to be able to have credit for those hours I did complete with my Second Opportunity, and basically have those converted to the fees to help with the fees. And I was ordered to get my license back. I submitted her my license within the first week. I paid those fees to get my license back, because originally I was put on probation for a suspended license. And I just want to make sure everything is being accounted for appropriately for the things I have completed. That's it, Judge.
Okay, so, what I'm hearing you say is that you completed the programs that you were asked to complete. Is that correct?
Yes, sir.
And that would have entitled you to how many hours of community service?
43 hours, Judge.
You're saying you submitted these to Ms. Peterson at the Citizen Enforcement Office?
Yes, sir, I did.
And you're saying she confirmed?
Yes, sir.
And, what were those 2 report dates that y'all alleged you missed?
November 15th, 2025, and December 15th of 2025.
All right, Ms. Talmadge,
Yes, sir.
coming back to you, did you miss a report date on November 15th?
Sir, I actually did miss that date, but I did email Ms. Peterson. I told her on the 16th that I was trying to report yesterday, and I sent her a screenshot of the site not allowing me to report. It said service unavailable, but I was able to submit that report a day late, or maybe 2 days late.
Okay, what about December 15th?
I'm not sure of that one, Judge. I probably did. I'm not saying I didn't, but it's definitely not both missed report dates.
All right, Ms. Sexton, do you have any questions you wish to ask?
Yes, so the certificates that that you were they sent to you digitally?
Yes, ma'am.
Okay, and did you ever print those certificates and bring them to probation?
No, ma'am, I didn't.
Okay, but you submitted them digitally to probation?
I emailed Ms. Peterson, yes, ma'am.
Okay, and when you emailed them, were they included as like attachments?
Yes, ma'am.
Okay. And I'm sorry, because I stepped in a little late. Did you get confirmation that those certificates were received?
Yes, ma'am. Because
And you have that confirmation in your email?
yes, ma'am. On a later date, I got an email from Second Opportunity, and I thought it was from Ms. Peterson. I was like, Ms. Peterson, it's here. Why did you resend that? I already completed. I said, what's this? And she was like, that email was sent from Second Opportunity, not me. And I said, why would you send me another email with login credentials? I forwarded the certificates as of last week. And that was her confirming that that she got my certificates.
Well, actually, that email sounds like
You need to let Ms. Sexton see that email.
Yeah,
'Cause
yeah.
that-
Can I come show you?
Absolutely.
Let's go off record real quick.
Okay. Okay, I got it. This is when, okay, this is, initially.
I think you found him, Ed. To be fair, Ed was diligently searching for whoever it was.
Oh, I'm sorry. I forgot to miss-
Ross, once again.
Let's go back on record. So Ms. Talmadge's phone was a little helpful, when Ms. Sexton was looking at it. What we're gonna do is we're gonna pause your testimony. We're gonna circle back to Ms. Matthews to help us clarify what this looks like from the state's position, and then we'll come back to you. It's not really the right way to do it, but I think it'll give us the best answers in this situation.
Okay.
All right, Director Matthews, if you'll fill us in on what's this deal with the submission of the certificates to your office?
So she did not get credit for the 5 certificates because she only needed the 2 to complete her 20 hours. So because she has not converted, they did not give her the rest of the credit towards there because there's no more community service on the case for credit to be applied to. And so I did confirm that we have the 5. But I have a print off here for the court to review on how the hours are allocated to their certificates. I have no idea how Ms. Talmadge gets that she has 43 hours with the 5 certificates. So intake into the program, once they pay $89, we give them 10 hours. The 5 certificates she completed would be for the first part, which would be second opportunity. That would be worth 24 hours. And then U-turn, if she completed that, would be 7. If she did all the CRI courses, that would be 15 hours. And I'd have to sit here and count them, Judge. There's easily possibly 15 in that section. If she was to complete all the soft skills, that would be an additional 14 hours. So the entire program would be up to 70 hours. But we're looking at, again, without me counting, approximately 30 certificates for 70 hours, Judge.
All right, that explains the difference between y'all's position and her position. All right, Ms. Talmadge, did that make sense to you, what was just testified to?
Yeah, it was cleared up a bit.
Because it made sense to me. All right, well, then we're gonna pivot back to your testimony, because again, I'm a little out of order, but I think it's gonna work. All right, what else? Tell me, now that we understand that you did get credit for those hours, it's just that you didn't, according to them, request that the additional hours that your fine be converted so that the additional hours could be applied to the fine conversion.
Yeah, I wasn't aware, Judge, of, that type of thing.
Yeah, it's it seems to me to be a communication issue. All right, what else do you want me to know?
That's pretty much it, Judge. I do want you to know that I have a valid license now. I did pay the fees to get my license back. And I want you to take that into consideration.
I see that here, and good job.
Yes,
Okay,
okay.
anything else?
That's about it, Judge.
Okay. Do you want to ask any additional questions?
No, I just want to comment. It appears that it's not in question that 5 certificates were submitted. But however you do the math, whether or not you are putting them on community service hours or converting them, you're still not converting them such that the fine is gone. I mean, it's only a modest, 5 certificates is not 90 hours.
That is correct. Okay. Anything else, Ms. Talmadge?
No, nothing else, Judge.
All right. Anything else, Ms. Sexton?
There you go.
All right, Director Matthews, back to you. We'll call this rebuttal. Anything else you want to fill me in on?
Ms. Sandwich does communicate with our office fairly regularly, and so if she had wanted to convert those hours, in one of the many phone calls or emails she sent, she could have requested that. In the consent offer that I presented her last week, I offered her to convert the fine. At that point that she refused. Had she came and discussed the case with us like you advised her to last week, we could have possibly cleared up some of these issues. She did show up at my office at 11:59 last Thursday, but I hadn't made it back to the office, so my staff was completely clueless to what had happened. They asked her to come back at 1. She did not, and we have not heard from her since last week.
Okay. Ms. Talmadge, anything else you want to sum up before I make my decision?
Well, I did go by the office after court, but Judge, I had been in court so long, I had to get my kids off the bus, and by that time, I just didn't. And I did speak with Miss Peterson, but she did tell me that she gave me 20 hours for the community service. It was brief because I believe they were going to lunch or coming from lunch, and yeah, that's why I didn't ever follow up. I figured I would just come back in front of you and discuss it here today.
Okay. All right. Then I'm going to find that that was closing. I've gotten the evidence all before me. So, Ms. Talmadge, part of what you're sensing from me is just that there should not be this level of chaos on these simple issues. And I'm looking back through my own docket. And I'm just going to go back to 2017 because that's the day I took the bench on January 1 of 2017. And I'm looking at 17 SR 38 obstruction. Actually, that was dismissed, so you can mark that one off the list. I got 18 TK 3361. I've got 19 SR 0367. I've got 19 SR 0368. I've got 19 TK 1849. Now that's just a ticket. You can remove that. I've got, then we jump forward to 24 SR 1331. And, do you have a felony pending upstairs?
Yes, I do, Judge.
Okay, that's 24 FAH 1833, but it looks like that was committed prior to the start of your probation with me. Not committed, but arrested, sorry. So that's just context. And so I guess what I'm trying to say is that this is not your first case with us. And I just don't see why there's so much chaos around these very simple questions about community service work. So what I'm going to do is I am going to find that there's enough here for me to find that you're willfully in violation of your probation. But what I'm going to do is, frankly, I'm just going to tighten the guardrail. So, for example, this is a terminate upon completion case. I'm leaving it is a terminate upon completion case because I want you highly motivated to fully engage and close your case, right? Because the moment you check your boxes, you're done. So as of this moment, I'm converting everything to community service work, period.
Fees also?
What if, no, the fees are still due. I mean, everything that this court traditionally converts to community service work is community service work. She's still responsible for her fees. I should have been more clear on that. I'm also, so how many hours a week do you recommend, Director Matthews, that would get her closed in a reasonable time frame?
She can complete it at the standard 6 hours.
Okay, perfect. So no less than 6 hours per week, community service work, but you can do more. And of course, there's a million ways in our book to get these community service work hours completed, as you're well aware. You can do the programs, you can donate the Promise Place, you can, do the hours yourself. But we're no longer going to be jumping around with money and figuring out how much is money and how much is community service work and what has been modified and what hasn't. I'm moving everything into one pot, and then you're going to finish that one pot, and then you're going to be done. Fair enough? Excellent. She nodded her head yes. All right, the second thing that we're going to do is that e-report is clearly not working. So she's now on in-office reporting. Because the e-report is, in my opinion, causing the missed report dates, causing the confusion, and by having her report in person, that will remove that from the issues. You will pick whatever her next report date is, Director Matthews, and she's on 0 tolerance until her case is closed. But again, you're terminated upon completion. So I brought the guardrails in really close, and I'm telling you to just get these things done, and your case will close. You have it in your ability to close your case tomorrow if you've done these things. In other words, I'm not holding you out any farther. You just need to get this done, okay? Because again, this is not your first rodeo with me. It's not your second or your third rodeo with me. And I am very well aware of who you are. I'm very well aware of how many times you've been through here. And I just want you to successfully close this case ASAP. Okay? Do you have any questions for me, ma'am, before we part ways?
Well, I guess you'll discuss with me how many hours of community service it'll be in.
Yeah, it's
The
just no
fees.
less than, the total will have to be recalculated. I don't
Okay.
know what that's going to be.
It's 75.
Oh, 75, so 75 hours community service work. Work with sense enforcement, get it done. What is her next report date?
February 18th, which is next Wednesday between 1 and 5.
All right, so, any questions, Ms. Talmadge?
No, nothing.
All right, Richie, if you will come get her to sign here, acknowledging my decision, and then give her a copy.
Sorry.
Yeah. All right, hold on. I'll get you a copy.
All right, thank you, Ms. Talmadge. Go get your case closed.
All right.
What else you got?
That's all for me, Judge.
Okay.
I think it's just Mr. Smith, I believe.
Smith, come on up.
It's a, motion for bond modification.
All right, this is one we also moved from last week to this week. This is a new one? Okay. All right, Mr. Smith, grab a seat right there. I'm just having you sit there because I can see the court reporter's microphone there. All right, Mr. Smith, raise your right hand. You solemnly swear or affirm the testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God. All right, take your hand down, state your full name for me.
Hunter Michael Smith.
All right, Mr. Smith, you're here today because you have requested that I modify your per diem, your bond conditions.
Yeah.
And what is it you want me to do?
I guess the bond modified, it's on like a nonviolent contact, so because my mom's still kind of part of my life, and she comes around my grandmother and stuff, and I have to hightail it, so we just want to be able to be in the same area, so it doesn't cause any more problems.
Okay, this is 25 SR 91, I see it here. Okay, Ms. Sexton, have you had a chance to speak with, the named victim, and does the state have a position on that request?
Two things. One, the named victim has submitted documentation stating that she would like the matter dismissed and that she would like to have contact again with her son. And when I spoke with her, because that information is slightly dated, I verified that information.
Okay,
So the state's position is, after talking with the named victim and after talking with the defendant, that the state does not oppose a modification to no violent contact.
okay. Ms. Evans, I see that he has not yet been arraigned on this case, so today is officially your arraignment date, as of this moment. So, I'm also looking to see if you have any previous cases. I don't see any previous cases, so I'll ask you, do you have any previous, family violence cases with me?
No.
Do you have
Don't
any
be very violent.
previous family violence cases anywhere in any court ever?
No, sir.
This is the first and only family violence case you've ever had?
Yes.
Do you have any other cases that are not family violence that are open and pending in any courtroom?
No, sir, not that I know.
Okay. All right, well then, and the answer is I will grant your motion then with the state's consent, to modify your bond to allow no violent contact. So that's a consent grant. Before you leave here, you will sign a reset notice because as of this moment, I'm pleading you not guilty, and I'm going to place you on the next available trial calendar. We clearly need to move your case forward at all due speed. You have the right to have an attorney represent you. Do you understand that? And if you wish to apply with the Public Defender's Office, their address and telephone number will appear on the face of the reset notice you're about to sign. If you wish to have them represent you, it is your responsibility to take action ASAP to secure their representation. If you come back to the next court date and you ask me for even more time to go to their office, which is 3 blocks from here, to apply, my answer will be no. Do you understand that if you want them, you need to move to go get them ASAP? Yes?
And I think someone gave me a piece of paper with their number on it too. So.
Yes, yeah, that it's usually being given several different ways to make certain that there's no confusion on that.
And, Your Honor, the
Yes.
defendant is currently unemployed and he would probably more than likely qualify
Okay,
for public assistance, for public defender.
all right, so I'm just gonna put that you need to go see them today or tomorrow then.
Okay.
All right, do you have any questions for me, Mr. Smith?
No, sir.
All right, don't make me regret this decision. Go and have peaceful, nonviolent contact with your victim. And I'm gonna try to see if I can put my hand on a form order that I can use here to get this box checked. All right, Ed, he's all yours.
Thank you.
All right, any other matters that need to be heard? Okay. All right, so with that said, issue the warrants, 450 cash bonds, it's 12/22. Court's adjourned for today. Nothing tomorrow, and we'll be back. I'll be starting a civil trial here Monday morning. And then Judge Essery is gonna call the ticket trial calendar upstairs on 2. So anybody who's on the criminal side of things, go to 2 Monday morning. All right, that's it. We're adjourned.